Hello, everyone. My name is May El Sadani, and I'm the Managing Director and Legal and Judicial Director of the Tahrir Institute for Middle East Policy. It's my pleasure to welcome you to today's session, Leveraging the UN for Greater Rule of Law Protections in the Middle East and North Africa and Beyond. In recent years, many states around the world have increasingly attempted to instrumentalize UN agencies, mechanisms, and doctrines to deteriorate the state of the rule of law. From Saudi Arabia heading the HRC Advisory Committee to Russia and China exercising their vetoes as Security Council members on Syria, despite doctrines like R2P, to the Egyptian state's advocacy to alter UN counterterrorism resolutions, there's been a widening gap between the ideals that the UN was created to uphold and its impact on the ground, particularly, but not solely in the MENA region. Today's panel, which will be run in the form of a moderated discussion, brings together an esteemed group of panelists who will ask if the UN, including its mechanisms and its doctrines, can be strengthened to better meet the challenges present in the MENA region, if there are credible and practical solutions that address why and how the UN system has been unable to meet the challenges of the day, and what role stakeholders can play to better ground the UN as an essential pillar in universal values and protect it from this greater politicization. I'll be doing 2 rounds of moderated questions, and then I'll be taking questions from the audience, which I invite you to submit using the Q&A function at any time during today's conversation. Without any further ado, let me introduce our panelists. Inez Osman is a French-Algerian human rights lawyer. As director of MENA Rights Group, she oversees and coordinates the overall implementation of the organization's mission. Prior to this, she worked as a jurist in international courts and human rights NGOs. She received her BA in International Relations from the University of Geneva and an LLM in Public International Law from the University of Leiden in the Netherlands. Ambassador Stephen Rapp was US Ambassador at Large, heading the Office of Global Criminal Justice between 2009 and 2015. Prior to that, he served as prosecutor of the Special Court for Sierra Leone, and even prior, senior trial attorney and chief of prosecutions at the International Criminal Tribunal for Rwanda. He is currently a senior fellow at the US Holocaust Memorial Museum's Center for Prevention of Genocide and at Oxford University's Center for Law, Ethics, and Armed Conflict. He serves as chair of the Commission for International Justice and Accountability and a senior peace fellow of the Public International Law and Policy Group. And last but not least, we have Renzo Pomi, a human rights lawyer with over 30 years experience in the field. He is currently Amnesty International's representative at the UN, covering human rights and humanitarian law in armed conflict and post-conflict settings, international justice, and accountability. He teaches human rights advocacy and research at NYU's Center for Global Affairs, and he received his law degree from the University of the Republic in Montevideo, Uruguay, and his LLM at Harvard Law School. Without any further ado, let's get started. When we talk about how to leverage the UN for greater human rights protections and access to the rule of law, it's helpful to begin by understanding the challenges that arise as a result of the design of the UN itself and its mechanisms and procedures. Renzo, if I may start with you, I'd like to invite you to walk us through how the very existence of different arms of the UN, whether the Secretariat, the Security Council, ECOSOC, or otherwise, pans out in practice for the MENA region. And if you can give us examples of what this means practically, and perhaps examples of how the structure or these systems may be instrumentalized by bad states.
Thank you, May. It's great to be here. Thank you for inviting me. I'll try to, I will make a general comment in reaction to your question, and then I'll refer to 3 particular challenges. I hope the time I have, it allows me to deal with all of that. But first of all, as I said, thank you for inviting me. Also, I would like to say that my organization, Amnesty International, considers the UN in particular and multilateralism in general as an essential tool for the promotion and protection of human rights. However, as you imply or said directly in your question, leveraging the UN for greater rule of law protection or for respect for human rights could be even frustrating. Many states indeed attempt to instrumentalize the UN for their own national purposes. This situation started right with the adoption of the charter itself. Professor Christoph Heinz have said that, or had spoke about a moral compartmentalization to refer to the attitude of those leaders who promoted lofty human rights principles as the basis for international organization, while imposing systems at home based on gross and systematic violations of those same rights, in particular, through domestic systems of racial segregation. It is clear that those leaders and others coming after them had little intention of applying at home the human rights norms espoused internationally. It has been in general up to civil society organizations to remind states of their commitments and to demand their compliance. As all of you know, for decades, the possibility of international human rights scrutiny was banned, in particular during the first years of the UN Commission of Human Rights. Eleanor Roosevelt's dictum that human rights were in small places, close to home, was ignored by the Commission for decades. Human rights would stay for many years in the orbit of thematic theoretic debates in Geneva, seemingly with no relation to those small places where men and women live. Nowadays, when the possibility of scrutiny is open, states still find multiple ways to block action, to avoid compliance with UN decisions and recommendations, to obstruct the work of its mechanisms, to not cooperate, even to threaten and intimidate. Let me now go to the three challenges that I want to refer to in particular. One is about membership in UN bodies. States in general disregard the provisions of norms that created UN bodies by ignoring membership criteria. For instance, according to the GA Resolution 6251, states voting to elect Human Rights Council members should consider the contribution of candidates to the promotion and protection of human rights and their voluntary pledges and commitments. This is generally ignored and horse trading abound. It does not help that most regional groups present clean slates, making all competition moot. The same resolution states that members elected to the council should uphold the highest standards in the promotion and protection of human rights. This often doesn't happen either. Some states seek membership to shield themselves from scrutiny and go as far as to harass, intimidate, and otherwise commit reprisals against those who cooperate with the UN or against the mechanisms created by the UN. Some of you may remember Burundi threatening with legal prosecution the members of the Human Rights Council created Commission on Human Rights in Burundi at the GA Third Committee a couple of years ago. It is well known that a good number of states serving in the Human Rights Council are listed in UN reports as perpetrators of reprisals. The second point I want to discuss was about peace and security. All of us have noted with concern the use of the veto, as you mentioned, May, by permanent council members to block appropriate responses to atrocity crimes and to obstruct the efforts to provide justice for victims. The use of the veto has allowed conflict to perdure and fester, atrocities to continue. The use of the veto or the threat of the veto has constituted a key obstacle to the prevention of conflict. Syria is, of course, the main example of the detrimental effect of the use of the veto, but by far not the only one. As my colleague and friend Jennifer Trahan has argued, in discharging its primary responsibility for the maintenance of international peace and security, the Security Council must act in accordance with the purposes and principles of the UN Charter. As she has said, arguably, many of the vetoes being cast at the Security Council do not accord with the UN's purposes and principles, and are close to an abuse of the power granted by the Charter. Giving a small minority of UN member states permanent membership in the Security Council and the power to block any substantive action is in itself problematic. The Security Council is not a very democratic and representative body, and its working methods are Byzantine and seems to be always provisional. Unfortunately, the Security Council is a perennial agenda item. The Security Council reform is a perennial agenda item in the General Assembly, one that seems to go nowhere. In addition, some reform proposals, such as the proposal by the African Group of States, echoes call for Africa to have no fewer than 2 new permanent council seats and 5 non-permanent seats. This would make the council perhaps more representative, but would also extend the veto power to the proposed new permanent members, which would make the likelihood of prompt action by the Security Council even more challenging. Of course, the veto is not the only problem that challenges the effectiveness of the Security Council. Even when decisions have been made, implementing them is challenging. Measures adopted under Chapter 7 of the UN Charter are binding to all member states, and yet states disrespect arms embargoes and other sanctions adopted under Chapter 7. Armed groups supported by Security Council members attack UN-recognized governments, such as in Libya. Groups or entities linked to a permanent member are alleged to be involved in military action against peacekeeping operations, such as in the Central African Republic, to name only a few examples. If you allow me, May, I would like to talk about civil society participation in the UN. Civil society actors and organizations have been a part of the life of the UN ever since the San Francisco Conference. We want to believe that we, civil society actors, are part of the people, as in the we the people of the Charter. Article 71 of the Charter states that the ECOSOC, the Economic and Social Council, it may make suitable arrangement for consultation with non-governmental organizations. To deal with those arrangements, the ECOSOC created no other than the ECOSOC Committee on NGOs, which is infamous for being the key blocker of UN participation in UN affairs. The way things are now on this front is an embarrassment that should not continue. It is not acceptable that the possibility of a NGO to consult with the UN would depend on the arbitrary views of a single member or several member states. It cannot be that a single question, no matter how irrelevant, could delay for years the consideration of an application for consultative status. The NGO committee membership cannot continue to be dominated by states which sole purpose for membership is to block NGOs they don't like. Just hear the current membership of the committee and you can judge for yourselves. The members are Bahrain, Brazil, Burundi, China, Cuba, Estonia, Eswatini, Greece, India, Israel, Libya, Mexico, Nicaragua, Nigeria, Pakistan, the Russian Federation, Sudan, Turkey, and the US. Some of these states dealing with NGO applications are listed as being themselves perpetrators of reprisals against NGOs and human rights offenders. What fair treatment can we expect from them as members of the committee? Finally, for those NGOs who managed to pass the codine forks that the ECOSOC Committee on NGOs have become, their participation in UN affairs is still limited, almost non-existent at the General Assembly, and their physical access to UN buildings is restricted. In normal times, NGOs representatives in New York have to compete with visitors and tourists for entrance to the UN. In pandemic times, our access to the UN in New York has been denied until this day. I can elaborate on this more during the second part of the panel. Thank you.
Thank you, Renzo. You've given us a lot to think about, and I appreciate you laying out kind of those three challenges very clearly. I want to jump to Inez, delving deeper into the Human Rights Council and the special procedures, which are your areas of focus, I know. Could you tell us a bit more about how the dichotomy between a system built on states' membership plays out, when in reality, it's really individuals who face harm, when there are non-state actors that are continuing to gain power, and when states have political interests that are at times at odds with the universal human rights system that the UN system is meant to be grounded in? What does this look like in practice, Inez?
Thank you, May, and thank you for having me today. So just before I share some thoughts, I just want to outline a little bit the Human Rights Council structure. So as Renzo mentioned, so the Human Rights Council is composed of states, not necessarily all doing great in terms of their human rights records, and they're actually the ones who vote resolutions that establish the mandate of special procedures, which are essentially independent experts or group of experts that usually have a thematic area of focus, like arbitrary detention or freedom of expression. And those experts are nominated by a consultative group of the Human Rights Council that is actually composed of 5 ambassadors. So it comes from member states, but then they are supposed to operate in an independent manner. They work pro bono. Of course, there's cons to that, and there's always like hurdles, as Renzo also mentioned in relation to Burundi, for example, that states are trying to undermine the work and the independence of those experts. What is very important to know is that the mandate of special procedures is supported by the OHCHR, the Office of the High Commissioner for Human Rights, which also provides like secretariat-like services to both the special procedures and the council. So ultimately, you have to understand that the HR, like the human capacity to do the work, is at the OHCHR level. The problem is that the OHCHR is funded by states. And as you can imagine, most are not exactly motivated or excited and dedicated to actually fund the OHCHR. And in practice, they're facing a lot of funding issues, and the system is pretty much overstretched. Just to give an example, I believe the staff, the Special Rapporteur on Torture, is only supported by like 2 staff members. So just imagine 2 people dealing with the issue of torture in the world. So just because of the way the system is made, there is already a tension in itself, and then the system is clearly overstretched because the OHCHR doesn't have the necessary resources to actually do all the work that they would want to do. What's important to say is that the OHCHR also has to work with states. And if you look at their mission, the first thing you see is that they work with and assist governments in fulfilling their human rights obligations, because obviously the duty to protect human rights is on the state. And that in itself can create at least some issues or frustrations from the view of civil society. Just to give an example, Saudi Arabia, which is one of the worst violators of human rights in the region, there is actually a technical mission of the OHCHR in Saudi Arabia that has been there since 2014, and that is supposed to train officials on human rights, increase the collaboration of Saudi with the UN human rights mechanisms. And if you think that that OHCHR has had a presence for the past 7 years, has the situation improved in Saudi? Like, I think it's fair to say that it hasn't been the case, except for some cosmetic changes. And the issue that we also, I think, as civil society face and, you know, in our interaction with victims, is that very often people come up to us and they're like, yeah, but what can the UN do? But ultimately, the UN is that state-based system, and they are working within those limits, and they can do miracles. So I believe that's always something that we have to keep in mind. In addition to the fact that none of what special procedures do is binding. Whatever they do are mere recommendations. Whenever they write to a state on a case, they're only making allegations that they have received. And so the system itself is can be quite limited. And the last issue that I would like to point to is that with this state-centered system, it has made the council and special procedures quite unable or unequipped to deal with challenges with regards to the role of non-state actors. And of course, in the MENA region, over the past few years, it has been an issue with many countries, whether that's Syria, Libya, Yemen, etc. And of course, a number of human rights violations are committed by those non-state actors. But then the problem is that the UN and special procedures, in theory, can only communicate with state entities. And the OHCHR is quite strict on that. And there's been some slight changes. For example, special procedures have started to increasingly actually write directly to businesses, for example. So that's one possibility. And for example, the special rapporteur on summary executions has also been very keen on saying, no, we're also taking up cases of executions by non-state actors, which is great. But ultimately, the willingness that there might be from special procedures mandate holders to tackle the issue of non-state actors is hindered by the fact that the OHCHR is like, no, but we're working with states. When we send a letter, we send it to the permanent mission. We don't send it to such and such armed group in a certain country. So there is also some, I mean, we clearly see the fact that it doesn't allow the OHCHR nor special procedures to deal with some of the most pressing issues in the region.
Thank you, Inez, for that. Ambassador Rapp, I'd love to focus with you on accountability and the rule of law. Your efforts have involved bridging what you refer to as the Hague-Geneva divide, i.e. this disconnect between UN human rights fact-finding and then judicial efforts to hold the most serious violators of human rights to account. Why does this divide exist, and what have existing tools like fact-finding missions, commissions of inquiry, investigative missions been able to accomplish versus what have been their limitations as well?
Well, great to be with the panel today and to discuss this topic. When you mentioned my biography, you saw that my background had been as a prosecutor, someone involved in criminal accountability and in holding perpetrators to account, particularly at two tribunals that were established, one by the UN Security Council directly, one by its authorization with the Secretary General to negotiate with the affected state. And of course, we had some success in the UN Security Council in the past, but not lately, in moving forward on these criminal justice cases and accountability for what are really the most serious violations of human rights, the attacks on the very right to life and human integrity and dignity. But obviously, since Syria, as Renzo said, this has been blocked. And so if you were looking for a multilateral solution, some kind of investigation, the go-to place became the Human Rights Council. And since Syria, we've had more than a dozen inquiries, I think, established in places where, frankly, the Security Council could not have acted. There would have been a veto, generally from Russia and China, certainly in one case even from the US. And so you have the Human Rights Council moving forward. And then, even though we know human rights, as we just heard, are involved with state responsibility, these mandates nonetheless ask for determinations as to whether the violations are crimes, and determinations, if possible, as to responsibility for these crimes, and refer specifically beyond international human rights law to international humanitarian law, covering the law of armed conflict, and international criminal law, the area that I'm into. What's happened is, of course, the inquiries have tried to do their best, and the longest serving one, and is certainly in history, and continues to serve, is the one on Syria, chaired by Paulo Pinheiro, that's now been in business for 10 years and issues great reports about every 6 months, covering the panoply of violations, tries to do a job on responsibility, basically says, of course, 90% plus of the violations are by the Syrian regime, but attributes responsibility in other places. On the other hand, from the beginning, they haven't had the capacity to do the kind of thing that we were able to do at tribunals. And they had a particular methodology of talking with victims, which is, of course, of great value in terms of giving those victims an opportunity to have their story told and to have the sort of range of violations described, but isn't perfect when it comes to linking those violations with the groups or the individuals that are responsible. And didn't have the capacity to participate with civil society and other groups that were frankly offering hundreds of thousands of pages of documents that were available in Syria in areas that fell to their armed opposition and were going to be burned up as fuel, and didn't have the capacity to deal with the millions of videos and to check the metadata, to verify, or to deal with other sort of digital things that are out there. And so there was that inability, even while we had these strong reports, to use it then when there came to be an opportunity to prosecute these cases in third countries, as we've seen most recently in Europe. I was involved in the US government in efforts to fill that gap with the creation of the Syrian Justice and Accountability Center, which was a hub to provide resources to civil society organizations that could build that documentation. And we've had groups like CIJA, which I chair, but also the Syrian Archive, also the Syrian Network for Human Rights, each of them becoming highly specialized in developing various aspects of evidence, to be frank. And then finally in the General Assembly, though it's been now almost 5 years since it began, the international mechanism was established, an independent mechanism over Russian opposition with the GA vote of 105 to 15, but largely to pull together the material gathered by civil society and by the Commission of Inquiry, and to serve as a go-to place for those that could use this material in criminal accountability. So that happened in that particular space, and I think it's an interesting model, because now we have, there'll be a major verdict in Germany in the Roslin case in early December, and there are other cases coming forward, and so we're actually seeing some of this coming through the UN, which is actually having a concrete effect on accountability in a place, despite Russian opposition and despite the splits, that it's been impossible for the Security Council to move. Meanwhile, of course, the Human Rights Council has proceeded with other ones from around the world where there would have been blockage: Myanmar, North Korea, Sri Lanka, Venezuela, Belarus. It's important to note that the Human Rights Security Council takes 9 out of 15 votes and no veto. Human Rights Council takes a plurality. Our abstentions don't count. So Venezuela went through 19 yes, 7 no, 21 abstentions. So it's sometimes possible to get these moving in places where it wouldn't be otherwise possible. But there is profound under-resourcing. The same challenges that we describe in Syria exist for most of these. And frankly, quite often in the UN budget processes, when the budgets come in, they take out the legal experts, they take out the IHL experts, et cetera, and sort of below the radar screen in the Advisory Committee on Budget Questions, we see these sort of these efforts eviscerate. Now, in terms of the MENA region, it is more interesting a story in a way, because there indeed the politics make it even more challenging than in some of these other places. There was a fact-finding mission, a brief one after the crimes of ISIS and the pushback against ISIS in Iraq, that reported, and it was when Zaid was High Commissioner, on violations that had occurred, massive violations by ISIS, by Daesh, but also by the popular militia, that were Shia-led militia that were fighting against them, and removal of Sunni communities, et cetera, and a variety of issues, of course, which outraged Iraq and some of its friends in the coalition. So that even that small fact-finding mission wasn't renewed. And so now when we've dealt with accountability on the crimes of Daesh and the crimes that have arisen in Iraq and Syria during the recent past. We've had the Security Council move forward with the creation of UNITAD, but specifically to deal only with the crimes of Daesh, and to focus most of its attention on prosecutions in Iraq, which continues with the death penalty and hasn't actually used any of this kind of evidence yet, because hasn't had, basically it's sufficient for it to prosecute people for being members. And though UNITAD has provided some assistance to cases in Europe, but you've had that particular challenge. Libya, of course, we'd had a commission of inquiry and a UN Security Council referral to the ICC early on. There's been more recently a Libya commission of inquiry. It's been, it was created when there was a hiring freeze. It struggled for 9 months to get anybody working. I mean, it's been profoundly under-resourced. It's now finally getting up and running. We've had, of course, a group of eminent experts. I mean, these things are often renamed if they don't intend them to be super powerful, if they're not to be investigations. And we know recently what happened on Yemen with a group of eminent experts, with the UAE leading the charge, and with the opponents of human rights generally, they actually succeeded in winning one of these plurality votes and beating it and stopping that mandate. And of course, there's Palestine, where the United States would be blocking an inquiry in the Security Council if one were offered. And there's the, the grievance, which I think has some merit that it's always on the agenda as item 7, and that's sort of a thing to beat it with. But it's frankly, knowing people that have worked in these inquiries, they're profoundly under-resourced. They have a hard time getting the IHL experts and the military experts, et cetera. So frankly, when they make findings, they're frankly easy to attack. And so there is this sort of pushback against effective inquiries in all of this area. And frankly, it would benefit the cause of truth, it would benefit the cause of justice if things were done more robustly. Obviously, everybody has a narrative. I mean, one of the reasons that the Paulo Pineros of the world weren't dealing with civil society is they said, well, these groups all have a political agenda. I frankly think you need to engage with everybody, and you obviously have to weigh things and corroborate it and everything else. But frankly, what's needed is, just the as they used to say in the old show Dragnets, just the facts. Let's lay out the law, let's lay out the facts, let's do a very, very solid job and use the tools that are available, even in these situations where the state is blocking access because of the digital media and other things. You've got tremendous ability, I think, to make progress. Talked to someone about Yemen from Bellingcat, frankly, who said, I didn't think there would be much open source on Yemen. He says, everywhere you look, et cetera. So if these things are properly resourced, you can do a fantastic job. And that's one of the reasons why I want to, as I deal with this Hague-Geneva divide, Hague being the home of international criminal justice, though of course, criminal justice can happen other places than the Hague, but it has in the UN, generally happened there. But it is basically a matter of making it more like the independent mechanism for Syria, and of course, we've got a new one for Myanmar too, and really build, I mean, you certainly need the advocacy, you certainly need the reports and a variety of things, I don't think, because these mechanisms don't issue reports, they basically build files. But they really have to have, I think, adequate support, and it's not just the situations where you decide to go forward with the mechanism, the other commissions do. And that's why the idea of creating an investigative support mechanism, a single global mechanism, of course, it would have to respond to a mandate. It couldn't just do with anything, but that could support the mechanisms, could support inquiry commissions and provide them with the legal expertise and the digital media analysis and everything else, and supply that across the board as required under their mandates, I think would be valuable, and then could also serve, like we've recently had on Sri Lanka, and as have calls in other situations, as the place where you would send a mandate in another kind of situation to do the kind of IIM work, to build files, to, in some cases, obviously, we hope that justice would be possible in the home country eventually, but in a way needs to be offshored at the moment, could provide the place for that. And of course, one of the fundamental issues that we as prosecutors have, and these cases can go on forever, there are Nazi camp guards being prosecuted, 76 years after the liberation of Auschwitz, you're going to need evidence for a long period of time. And one of the things everybody tells me about trying to get information out of the UN is that it's almost impossible. It's an average of 3 years to get something from one of these commissions that's already gone out of business. So this whole thing needs to become more user-friendly too, in terms of actually the justice processes, which aren't the only way to get to justice, not the only way to accountability, but fundamentally are what the perpetrators fear. And it's the absence of the jurisdiction, the absence of courts on the beat that I think has sent the signal to people like Assad, like the Tatmadaw in Myanmar and elsewhere, that they can get away with these crimes. And to the extent that we can build a more solid evidence and find a way into court, we can begin to protect people more than has been possible in the last decade.
Thank you, Ambassador Rapp, for that. I'm going, just to remind our audience, I'm going to do one more round of questions that I've written up, but I would also, after this point, welcome questions from the audience. So please share them, whether on the chat or the Q&A function. So I'd like to build on what our esteemed panelists have shared so far with an eye toward practical solutions, and some of that has already come up, and really the role that states, civil society, experts can play in molding or adapting the UN to meet today's challenges in the MENA region and otherwise. Inez, I want to go back to you. We are working with a state-centric system in the UN, but despite this state-centric system, what successes have you seen civil society achieve? And what lessons does this tell us going forward? And maybe what can be done to make the UN more accessible, inclusive, effective to the needs and realities of advocates, be they in civil society organizations or otherwise?
That's a really good question, May. So I don't necessarily want to name a specific example of success, but I do think that civil society, despite all the hurdles that we discussed and that we'll discuss some more, civil society is present, especially I think in the council special procedure space, whether that's pushing states for statements at the council or submitting information to special procedures. To be honest, it's even hard for me to think what special procedures would be doing without civil society in the broad sense, not just NGOs, but also lawyers, activists, etc., because they are the first source of information to submit complaints, but also whenever special procedures want to visit a country, where do they go first? They ask civil society, do you have recommendations? Who should we meet? So I think civil society is really essential to the functioning of those mechanisms because they feed information, they push, they advocate. But I think also because at the end of the day, civil society is the actor that's also going to take whatever comes out of the UN to do some more advocacy. So whether that's UN recommendations, etc. Like we also take whatever we can get and we try to use it and amplify it. And I also think that civil society has, I don't know if it's a good or a bad thing, but has been quite resilient. And I think we've been able to adapt to the system despite the many flaws of the system and sometimes the frustrations that we can just encounter in our day-to-day work. But in terms of how the system is or is not inclusive, etc., in my opinion, the system as is now is rather elitist to some extent. I think it's made for people who have the know-how. In any case, like people who know how the system works. Pre-COVID, it also used to be easier if you're in Geneva and you're able to interact with diplomats, with the UN, etc. So already, you know, the physical presence is a bonus. The other big issue, in my opinion, is the Arabic language. Despite Arabic being a UN official language, it is not really spoken by many of the experts or even staff at the OHCHR. We often have to, you know, translate information, even if we have even less capacity than the OHCHR itself. So that's quite a problem. And in my opinion, it's not, the system is not designed to be accessed by everyone on an equal standing. So that's an issue. in itself, but I also think that this lack of accessibility is reflected too in the type of cases and situations that are picked up by UN special procedures. So for example, you would see prominent kind of high profile cases having like 10 or more individual communications on their cases, statements by special procedures, which, you know, is good, but I also feel like there is very much of a difference between, like, a difference of treatment between certain high profile victims, if you allow me to call them that, versus others. So there is definitely, yeah, like an inequality there. And I think it's in part because of how the system is built, but I also think, might be an unpopular opinion, but it's also due to the way civil society works, kind of picking up maybe more well-known prominent cases or trendy issues. And I feel like a lot of the victims are maybe less known, or the individuals that, you know, do not have the same level of access or connections, then don't necessarily get much visibility for their situation. Of course, there is the problem that Renzo highlighted before, which is the ECOSOC status. So special procedures can be accessed or contacted regardless of whether you have the ECOSOC status or not. But everything that's Human Rights Council related, organizing side events, speaking at the council, etc., you need to have the ECOSOC status. And as mentioned before, the system is just like one of the most shameful, I think, design of the UN, and that's one of the top hurdles to like equal civil society participation at the UN level. And the last point that has also been highlighted in relation to New York, but that we've also seen in Geneva during the pandemic, is that as soon as UN access was restricted at the very, very beginning of the pandemic, the first thing they canceled during the Human Rights Council session was civil society side events. So it feels like, you know, whenever we are needed, whenever the UN is like, oh, can you provide us with info? Can you do this? Can you do that? We're always there and present. However, we were the ones that the UN kind of got rid of first. And we still are to this day unable to access the UN. So it's, yeah, it always puts us in a bit of a difficult situation. And I think, you know, for the system to be reformed, we have to have willingness of states, which might be difficult to obtain. But yeah, ultimately, sometimes it doesn't feel like we maybe get the recognition that we deserve. And obviously I'm biased, and I think so are we in this panel, but yeah.
Thank you, Inez, and I appreciate that insight and that perspective. It's important for folks to hear, because at the end of the day, yes, this is a state-centric system, but a whole host of stakeholders are meant to participate in it. Ambassador Rapp, I want to turn back to you, and I want to ask you about the mechanisms you referenced as an important step. But what about international tribunals? We're seeing some trials in European courts for abuses committed in MENA. You mentioned the example of Syria most prominently, but we're not necessarily seeing international tribunals via the UN system for the MENA region. Why has that been the case in your assessment? And what practical steps can be taken toward changing this? And should we be trying to change this?
Well, as we know, there's certainly been international tribunals with jurisdiction over cases in the MENA region, and it hasn't been a process where there's been much success. Of course, in the Libya referral, we had we still have an arrest warrant for Saif Gaddafi that hasn't been answered, even though there was a determination that case couldn't be done in Libya. I recall there was, because I was helping on it, there was a particular individual who led the internal security agency for Gaddafi, General al-Tahami, who was actually given refuge in Egypt. And because of that, for 4 years, from 2013 to 17, his international arrest warrant was under seal while I helped everyone tried to say to the Egyptians, this would be very good if you'd surrender this guy. And of course, they never did. He's sort of their kind of guy, Sisi's kind of guy. And now, of course, it was unsealed in 2017, and there's been no cooperation on that either. I think of the Special Tribunal on Lebanon, obviously demonized by the Shia side, frankly, and certainly by Hezbollah, because it's cases, it's in absentia cases, essentially allege that certain leaders of Hezbollah were involved in the assassination of Hariri, and of course we have to recognize that wasn't an international tribunal for war crimes or atrocity crimes. But of course, even though the Lebanese state technically cooperated with it and provided 50% of the funding and responded politely to arrest warrants, South Beirut and various parts of the country were no-go areas. And it's kind of too bad. I mean, if Badruddin had been arrested, he wouldn't have been killed in Syria. You could have stood trial in The Hague and had all sorts of lawyers, and we would have had a more active process. But of course, that all proceeded almost invisibly in absentia, though there was, of course, a trial judgment, and now, because of the disappointment in that process, in part, there's no funding to continue that court to a large extent, or to do connected cases, perhaps to handle appeals. Of course, it's emblematic exactly what's happening in Lebanon itself, where the trusted magistrate who's investigating responsibility for the horrific explosion in the port is himself being demonized and attacked and facing physical assault for daring to do an independent investigation that might reach to individuals in high places. So that's and of course we've got Sudan, where at least I thought, so some of us had such great hope after the popular uprising and the formation of this transitional government, and promises to deliver finally people including Bashir to The Hague, and promises that were only weeks away from fruition. And of course, we've had a coup d'etat, which we hope will fail, and that we'll still have movement in that direction. The Hague did eventually get Ali Kachib, but he actually surrendered and had to go all the way to the Central African Republic to get anybody that would cooperate in sending him to The Hague. To be frank, it took several years to organize that. So, zero cooperation for international cooperation in the region, even where you've had Security Council referrals. And that's the challenge. Now, of course, how did courts work elsewhere? And nobody wants to prosecute their own. And there's political pushback. But, the contrast, the former Yugoslavia, where the European region was all in and said, you have to cooperate or you can't move forward into EU accession, and conditionality became extremely important and resulted in, Serbia cooperating and giving up people that many of citizens thought were heroes to stand trial in The Hague. So there really was within the region this sort of support for the idea, and putting into your acceptability to be part of the community, the essential demand for adherence to the rule of law, which included your adherence to obligations under the UN Charter that were issued under, frankly, Chapter 7 of that charter by the Security Council. So that was an extremely important part. By contrast, we have in the Arab region, I mean, it was, of course, a moment when Syria was suspended from the Arab League, but now we get a variety of regimes wanting to reconcile with it, even while, 500,000 people are dead, and 13 million people are displaced, and the idea of rebuilding is rebuilding on the property of people that have been tortured to death without their consent. So there are challenges to moving forward in that direction. But as we saw on the Yemen inquiry, we've got countries in the Gulf that are frankly working and frankly supporting bad actors in a variety of places, including Sudan, and pushing back against democratic rights, et cetera. And so you've got that kind of real division and well-resourced leadership against accountability, against the rule of law, in favor of control for the by the powerful and the rich for their own preservation and continued control. So trying to get around that is difficult. I mean, I'm always looking for the more positive things. I mean, I would like to see, if not, trials in the region, to be frank. But, and of course, we recognize that probably one-sided trials. I mean, but not the kind of trials we're getting in Iraq and in the terrorism courts. Kind of trials, at least the Kurdish region was talking about putting on without the death penalty, with real proof, with disinterested judges, with some people acquitted when the evidence wasn't good. I mean, but at least moving forward in a direction where we see the rule of law protected, and where you can have kind of a rather than a downward malignant spiral, an upward virtuous one, et cetera. And I think that's frankly what it takes. So obviously, I much prefer that prosecutions happen on both sides. But I mean, the International Criminal Law Project began at Nuremberg with I think fair prosecutions of only one side. And so let's at least get there. And if we can, I think we begin to move in a positive direction. Now, that's not to say that there aren't some countries that are doing terrorism cases in better ways than others, but there's still fundamentally cases about membership or support and not about conduct. And certainly to the extent that we're more concerned about the crimes by the extremists, by ISIS, Daesh, it's much better if those cases are about conduct, about selfish, brutal conduct, rape of girls and sending people into slavery, and a variety of that kind of conduct, which I think is a much more effective sort of antidote to recruitment, which often, being a martyr because of an association, is easily used by those that are charged. So, largely in the region, it's going the wrong way. And I suppose only from the external point of view, the lesson should be, though, of course, you can't count on, external actors having control, but obviously other states need to be much more careful, much more useful at using their own leverage to insist that these commitments be made, and without doing it in a heavy-handed way that can easily backfire, but it really conditioning a variety of relationships, I think, on positive movements in this direction. But obviously, I think at the end of the day, it takes movement in the region, and frankly, in the region, it's going the wrong way.
Thank you, Ambassador Rapp. Renzo, I'm going to turn to you for one final question in this round. We've just unpacked a whole host of challenges and weaknesses, but based on your years of advocacy and engagement with the UN system, are practical solutions being presented to address issues like the ones you raised earlier on civil society accessibility, on deeply entrenched challenges like the UN Security Council veto? I'd invite you to weigh in on the availability of solutions, giving examples where possible and where you might be comfortable, and maybe what can be done to begin to make those changes in the UN system, or at least mobilize around these solutions.
Thank you, May. Before going to well, first of all, the issue of solutions is, of course, the most challenging one. Is something that we wish we had the solutions to make the system more effective. And there has to be a process of discussion to come up with solutions that would address the enormous challenges that the world has today, as, for instance, described in the latest Secretary General report on our common agenda. So some think that the UN system shaped on an idea of the world from the 1940s should be changed to be able to address those challenges that we are facing, because the world in the post-pandemic will certainly be very different than the world we live now. But of course, I don't have the solutions on how, or the recipe on how to reshape the UN or to reshape international organization. What I can say is to comment a bit on, as you said, on the challenges that I mentioned at the beginning. So going to those three, in terms of membership, as I said, states normally ignore the membership criteria established by the UN and end up selecting countries that have bad records on human rights, as Ines mentioned. In addition, the secrecy of the vote gives electing members, even members that are human rights friendly, the chance to avoid accountability for supporting those problematic candidates. But I want to refer to one thing that Amnesty does every year that I think is a good contribution to try to make progress on this topic. And every year, Amnesty and the International Service for Human Rights organize Human Rights Council elections pledging event to allow candidates to present their pledges and vision for membership. This is the only occasion that I know in which the public has the chance to hear from the candidates and interrogate them on their qualifications and plans. This should not be only a civil society initiative. This kind of debates should be formalized. It should be mandatory for all candidates. The weight of instilling transparency into the process of selecting candidates should not come down to NGOs to demand only. It should be a goal espoused by all. In addition, regional groups should avoid the practice of clean slates, as mentioned before, and allow competition to exist. Some kind of exercise of this type should be the norm also for the elections of mandate holders and members of treaty bodies. Competition and transparency should lead to elections based on merits and other established criteria, including independence. States should not put government officials forward as candidates, expecting the international community to believe that they are independent experts. Let me go to peace and security. As I mentioned before, the paralysis of the Security Council must be tackled, in particular by taking measures about the responsible use of the veto. Since at least 2005, different countries and other organizations have proposed ideas on how to limit the pernicious effects of the irresponsible use of the veto. None of the proposals have so far suggested getting rid of the veto. As for that, an amendment of the charter would be needed. And as you know, a full reform of the charter has several, could have consequences that may be problematic. My organization supports any initiative that would limit the use of the veto in situations where crimes under international law are being committed. But I would like to refer briefly to one of them, which seems to me the most comprehensive and promising. This initiative is the Code of Conduct regarding Security Council action against genocide, crimes against humanity, and war crimes. This proposal has been put forward by the so-called ACT group of states and aims at enhancing the effectiveness of the Council, including by putting constraints on the use of the veto. The code is meant to encourage timely and decisive action by the Council to prevent or end the commission of genocide, crimes against humanity, and war crimes. It urges all member states not to vote as members of the Security Council against a credible draft resolution on timely and decisive action to end those crimes or to prevent them. The code also invites the Secretary General to bring to the attention of the Council situations which in his assessment would involve or are likely to involve those crimes. Those supporting the code pledge to fully and promptly take into account such assessment by the Security Council. And we have now about 120 member states already supporting the code of conduct, including 2 permanent members, France and the UK. So the code of conduct and other such initiatives for sure won't fully fix the problem of the veto, but at least as the more countries subscribe to these initiatives, the bigger the pressure will be on those intending to oppose timely and decisive action by the Security Council, and bigger the cost they will pay if they do so. The next step will be to force permanent members acting irresponsibly to explain to the UN membership, perhaps through the General Assembly, why they decided to act in a way that clearly seems to contradict the purposes and principles stated in the Charter. And finally, on civil society. As I mentioned before, the ECOSOC Committee on NGOs has acted consistently as a gatekeeper, keeping certain civil society organizations out of the UN, and also making life difficult for those who already have consultative status with the UN. The working methods of the committee are, in my view, a mix of Kafka and Monty Python. And I can explain that if you would like me to, but I know I don't have enough time. But it's really something, the working methods are. They allow any of the 19 committee members to block a recommendation of consultative status just by asking a question, no matter the relevance of the question. And I can tell you, normally they are very irrelevant. This, of course, should change. ECOSOC members should be embarrassed by what its subsidiary body is doing. A working methods reform should make sure that all applications are promptly, fairly, and objectively considered, and that decisions are made based on the merits of the application and not on unrelated issues related to politics, ideology, religion, nationality, or others. In addition, countries that support the work of NGOs should be themselves candidates and oppose candidates with track records of human rights violations and attacks against civil society. However, being accredited to the UN, as I believe Ines mentioned, is not the end of the story. NGOs have a very limited participation in UN affairs in any case. Some participation is possible in Geneva, but in New York, participation is minimal. NGOs are in general not allowed to speak at the General Assembly, both in the plenary or in the main committees. And regarding UN conferences, states normally adopt procedural resolutions that normally keep NGO participation to a minimum. The third committee, which discusses human rights resolutions, does not allow human rights NGOs to participate. And states in general avoid inviting NGOs to attend informal negotiations on drafts. There is nothing, in my view, that impedes states to invite NGOs to speak at the UN in New York or to participate in negotiations. It is only a matter of political will. As said before, for almost 2 years, NGOs' physical access to the UN in New York has been denied. For months now, all other actors have been given access to the UN buildings, but NGOs, on the other hand, cannot even properly apply yet for the UN passes that they are owed as groups affiliated to the UN. If the Secretary General is serious about how much he values the work of NGOs, as he has repeatedly claimed, he should allow us in immediately. Thank you, May.
Thank you, Renzo. We just about have 10 minutes and we've already received 3 audience questions. So what I'm going to do, I'm going to ask the questions all together, and then I will invite each of the speakers to weigh in on any of the questions that they find comfortable, just so we optimize time. I know we can talk about these issues forever. So I'm going to summarize some of these, but we have one question from Leila Sadat. Number 1, any chance that the US might join the Code of Conduct and issue the veto? So that's one question. A second question I will put out there. Professor Tladi discussed in the plenary that states in the global South often have less capacity to influence at the UN because of lack of resources or a seat at the table. Do you think that if they were able to participate more in mechanisms, would states be able to meet challenges in MENA? It seems to me, the person who submitted the question, that many of the countries with a more direct interest in the region may have less of a voice at the UN. So it's a question asking kind of about representation of MENA states or otherwise who have interests in the UN and if that might change things. And then the final question I will put out there for this round asks specifically about the recent decision by Israel's defense minister to designate 6 Palestinian civil society organizations as terrorist organizations. The question is, are nation states allowed to do this? I'm going to add to that and ask perhaps kind of how states can hold each other accountable when decisions like this are made that marginalize civil society and that perhaps go against human rights principles. So I will invite the speakers to weigh in on any of the questions they like. Ambassador Rapp, would you like to jump in first?
Mute. Okay. First of all, on the Code of Conduct, I would like to see the U.S. Go along with the Code of Conduct. I do recall during the Obama administration that the proposal was forward, and the U.S. through its interagency process was not favorable. And part of it concerns the role that the U.S. plays in vetoes, particularly on relationship to resolutions on Israel. And we saw the strong pushback when the United States didn't abstain from or didn't veto the resolution at the end of 2016, and the political pushback in Congress and everything else. So it becomes a difficult issue for U.S. government. But obviously here we're talking about the most serious crimes known to humankind. We're not talking about every kind of issue or resolution, and we're talking about having investigations that are done in an even-handed and judicious manner. And it seems to me that in that regard, there ought to be veto restraint. Now, of course, it's sort of unilateral disarmament in a way, unless everybody agrees to it, and Russia and China are dead set against it. But in principle, I think this is something on which the U.S. should responsibly take a lead, and I would hope the Biden administration would do that. In regard to the terrorist designations by Defense Secretary Gantz in Israel, the administration has spoken out and frankly strongly criticized this decision to put, based upon secret evidence, these groups on terrorist lists and potentially open their activities. There were some activities in terms of documenting alleged human rights violations into a situation where it could be criminalized, where people could be prosecuted. I'm a believer in the use of sanctions and in designations, and of course sometimes there is secret evidence, but there really has to be a public file, redacted if there's security issues, and shared with other governments in terms of those. I think the Israelis have offered to show it to the U.S. potentially, but it's easy for that process to become a very invisible one. There has to be a public aspect of it, and we know in Europe, for instance, when sanctions have been issued against individuals, they've taken them to the European Court of Justice and often have them set aside. And it's one of the reasons why I frankly support efforts for these mechanisms to actually provide resources for sanctioning mechanisms, because it wouldn't be classified intelligence community stuff. It could be disclosed to judges, et cetera. So I think, and obviously the dangers that we get into across the world are the ways in which NGOs are prohibited, in which they're prosecuted, and in which we close off access to information. And it makes everything worse. And so I personally would strongly urge the Israeli government to suspend this action and to the extent that they have evidence, to find ways to present the evidence and find ways for groups to present evidence to the contrary, and to decide this process fairly, rather than on the basis of secret listing.
Thank you. Inez, I'm going to turn to you. Please feel free to answer as you like, and let's keep our answers, if possible, to about 2 minutes so that we end not too far off time. Thank you.
Sure, thank you. So with regards to the designation of the 6 NGOs, I mean, our nation states are allowed to do this. Technically, there is nothing that actually forbids them from doing that, but I believe that it's also related to, you know, the essence of international law. There is no agreed upon even definition of terrorism. You know, so it's definitely an area that I think states know they can play with, and, you know, designing people as terrorists when they're in fact just like doing peaceful human rights work is not something that Israel has the monopoly of, unfortunately. And we also see that in many, many other countries in the MENA, but also elsewhere. And I think the response to that is going to be quite interesting to see, because in my opinion, the issue of Palestine, you know, is one of the ones that has been going on for the longest. And we also see the limits of the UN system clearly, as we've discussed before. Then in terms of countries from the global south engaging or not engaging enough, yes, I mean, you do see many seats at the council that are always empty because people actually don't even have the means to afford to have like diplomats in Geneva. But I do have to put a caveat, because I don't think it's necessarily always linked to financial resources. And I think sometimes some states, if they want to put in the resources, they find the resources. And I'm thinking, for example, of Egypt, which is actually known to be one of the most aggressive team of diplomats in Geneva. They are everywhere and, you know, always trying to push resolutions to block things. And you could compare them with, for example, some Gulf countries, which clearly have much more means, financial means to, you know, hire people, do that advocacy, and yet they're also extremely present. So I don't necessarily think it's linked to the financial resources, but rather the will to actually put those resources at the disposal of the Geneva Council or whatever else other UN system.
Thank you. And Renzo, last but not least, please.
Yeah, I know I have like 30 seconds for each of my responses, but I let me just echo what my colleagues just said, and in particular in terms of the code of conduct, I agree totally with Ambassador Rapp that I think there is very little chance for the US to join, although it would be good to try and lobby the new administration for which certainly has a more favorable approach to human rights and justice issues than the previous administration had. So it's a work in progress, although it's difficult to be very hopeful. In terms of the Palestinian groups that were declared terrorist organizations by the Israel government, we have already expressed ourselves condemning this move, and the only thing I can say is that our solidarity goes with them, and let's hope that Israel review the decision soon. And I also want to echo what Inez was saying, that, and this may require a very long discussion, is how, as in the past, when I was younger, communism was the excuse that every government put to undermine the work of human rights offenders and activists and others. Now the common boogeyman is terrorism. And as Inez said, it's not only in Israel, close to Israel, in Egypt, is very clear that this is happening, as well in other places. And so, yeah, that's what I want to say. And let me say thank you again for allowing me to participate in this great panel.
Thank you. Thank you, everyone, to our esteemed panelists. It was such a pleasure hosting you. I know this is a huge topic, and I know we only scratched the surface, but I hope our audience members walk away with a greater understanding of the challenges involved, as well as some solutions that civil society advocates and experts in the accountability space have been advocating for. So I want to thank our audience for the wonderful questions. I want to thank our panelists for the really insightful comments. And I want to thank the International Law Weekend for providing us with the space for this conversation that will hopefully only continue. Thanks, everyone.
Thank you.
Thank you, May.
Thank you.